Day 43. Trump civil fraud trial. The fallout of the civil fraud trial on Trump defense. Former President Donald Trump has decided not to testify again, on Monday, at his New York civil fraud trial. During his previous testimony, instead of answering questions from the New York Attorney General's office, he criticized the judge overseeing his case and the Attorney General's lawsuit against him. The questions on Monday would have been more favorable to Trump, as he would have been questioned by his attorneys to strengthen his defense against allegations of fraudulent property valuation. Trump's decision not to testify comes as he continues to criticize the civil fraud case brought by New York Attorney General Letitia James, who is seeking $250 million in damages and a ban on Trump from doing business in the state. The judge in the case, Arthur Engoron, has already ruled that Trump and his co-defendants are liable for fraud. The trial is ongoing, and the outcome could have significant consequences for Trump's business dealings in New York. What else can we observe? Trump team justification of the no-show. In a social media post this morning, Donald Trump asserted that he wanted to testify on Monday but cited the trial's limited gag order as the reason for his decision not to testify. He expressed frustration over the gag order, which prevents him from commenting on Judge Engoron's staff, and claimed that it infringed upon his constitutional right to defend himself. Trump emphasized the strength of his evidence and previous testimony as factors that influenced his choice not to take the stand. Trump's attorney, Chris Kise, also partially attributed his client's decision to the unconstitutional gag order imposed by the judge, stating that it appeared to disregard President Trump's testimony and that of others involved in the case's complex financial transactions. The result of having a worthless clause. Trump's legal team consistently champions a section of his financial statements labeled the worthless clause, emphasizing its significance in insulating Trump from alleged wrongdoing. Trump himself testified during the state's case, emphasizing the clause's explicit directive for stakeholders to conduct their own due diligence, work, and study, cautioning against taking anything for granted. This disclaimer, according to Trump's lawyers, serves as a robust defense since it communicated to lenders the potential inaccuracies in the statements, a stance fortified by defense experts' testimony. Accounting expert Eli Bartov, part of the defense, deemed the disclaimer crystal clear, asserting that even a 9-year-old could comprehend its language. Despite Judge Engoron's initial dismissive stance in his partial summary judgment, where he declared the reliance on these disclaimers as worthless, he showed some flexibility after Bartov staunchly defended Trump's use of disclaimers, stating, "I am fairly liberal in reconsidering my opinions." No proof of conspiracy. The defense team for Donald Trump staunchly asserts that there is a conspicuous absence of evidence substantiating the alleged conspiracy to inflate the former president's net worth. Trump's attorney, Chris Kise, emphatically argued in court that the state attorneys have failed to establish a fundamental premise essential for supporting the conspiracy claims, an agreement, which, according to Kise, is notably absent from the record. Additionally, the defense underscored the unreliability of Michael Cohen, the state's primary witness, citing his history of false testimony and asserting that he cannot be trusted. Referring to Cohen's credibility, Trump himself emphasized the gravity of the situation, stating that Cohen's dishonesty should conclusively terminate the case. Furthermore, during cross-examination by defense lawyers Alina Habba and Clifford Robert, it was revealed that Trump Organization Vice President Patrick Berney received directions to increase Trump's net worth from then CFO Alan Weisselberg. However, when Berney was later recalled as a defense witness, he clarified that he never inflated values in Trump's financial statement without supporting evidence. Is lenders' satisfaction irrelevant in a fraud case? In court, it has been asserted that the claim made by former President Trump, stating that his lenders were content with doing business with him despite alleged inflated valuations, is a central pillar of his defense. Testimony from Rosemary Voroblik, a former managing director at Deutsche Bank, revealed that the bank actively sought Trump's business, aiming to earn substantial interest and fees from his loans. Additionally, defense expert Robert Annell testified that even if Trump's net worth was significantly lower than claimed, he would still have qualified for the loans. Annell further stated that the bank's internal valuation group determined Trump had overstated his net worth by approximately $2.4 billion when offering him loans, implying that any inflated valuations were irrelevant to the lenders. However, Judge Engoron expressed skepticism regarding the viability of this argument, emphasizing that satisfying the lenders does not absolve Trump of potential wrongdoing. Engoron stated in court, "The lender's satisfaction alone does not negate the violation of the statute." Chris Kise accuses the state of withholding key witnesses. In a courtroom exchange, Trump attorney Chris Kise asserted that the New York Attorney General was withholding witnesses, contending that the government had deliberately held back key individuals. Keiss argued vehemently against allowing the state's rebuttal witnesses, Cornell professor Eric Lewis and former Trump Organization executive Kevin Sneddon, claiming they were intended to fill evidentiary gaps rather than provide a genuine rebuttal. Accusing the state of gamesmanship in withholding evidence, Keiss sought to prevent the testimony. However, Judge Arthur Engoron overruled Keiss's objections, emphasizing that he saw no reason to bar the purported experts from testifying. In response, Trump's defense team hinted at the possibility of presenting an additional witness after the state's rebuttal case, keeping the legal proceedings dynamic and contentious. Defense's presentation to conclude today. Donald Trump's legal team is set to end their case today after presenting 4 weeks of testimony in the former president's civil fraud trial. New York University accounting professor Eli Bartov will be the final witness called in Trump's defense, as he will be cross-examined about potential bias in his analysis of Trump's financial statements. Bartov was paid an hourly rate of $1,350 for a total of 650 hours of work by both the Trump Organization and Trump Save America PAC. Last week, he strongly defended Trump's financial condition statements, which are the focus of the New York Attorney General's case, stating that he found no evidence whatsoever for any accounting fraud. Additionally, Bartov argued that the documents were insignificant to banks that loaned Trump money, as they used their analysis to make their loan decisions. He said, "It is impossible to argue, it is absurd to argue, that Deutsche Bank or any lender would make lending decisions based on the statements of financial condition. This should close the book on this case. Trump will not be called to testify as a defense witness." Thanks for watching. If you like it, comment and hit the like and share buttons. Subscribe for future videos.